We have a busy agenda today, so thank you all for participating and for being here with us. We first have an update from the Judicial Branch, which we will hear from Sean Jurgensen, Special Counsel to Chief Justice Marla J. Luckert. So with that, then, we will invite Mr. Jurgensen to the podium. Please introduce yourself and welcome back to committee.
Thank you, Madam Chair. Can you hear me? Well, good morning. My name is Sean Jurgensen. I represent the Kansas Judicial Branch. Thank you for the invitation today to discuss an update on the Kansas Judiciary, specifically the status of criminal caseload in our district courts. Kim passed around a packet, which is a copy of the letter and attachments that the Office of Judicial Administration provided to the committee back on January 17 in compliance with 2021 HB 2078. And so if you can direct your attention there, that's what we'll be mostly reviewing during our update. But before we jump in, I wanted to start with how we started last year. And we want to thank you again. As our legislative colleagues, last year you responded by providing us with additional tools that we can use in the court system to better respond to the pandemic. And those tools played an integral part in the more than 31,000 criminal cases that were resolved in FY21. And as you see in the data provided by the Office of Judicial Administration, regularly folks will come before the committee and have a complaint or an issue that we seek to resolve, and we do our level best at fashioning that remedy. But I'm here to report to you today that the response that you helped the Judicial Branch craft is working in the court system. So, Madam Chair, the state of criminal jury trials in Kansas is positive, and statewide criminal cases are resolving, including by jury trial when needed. And so if you would turn your attention to Attachment 3 on the packet that OJA sent over, Attachment 3 is a grid that shows the jury trials that were resolved, or the number of jury trials that occurred in FY21. And as you're scanning down that list of the number of jury trials that were completed, I wanted to let you know how data is collected in the Judicial Branch's system. And so a jury trial isn't counted in our system until the case is disposed of. And so while there could have been a jury trial that happened during FY21, if sentencing hasn't occurred, the case isn't disposed of and it doesn't ping in the system. And so this is the most accurate data that we can provide you, but just know that, there are instances where a jury trial has been conducted, but the case isn't fully disposed of yet because an issue is still outstanding, like sentencing, and so it wouldn't have been counted yet. But all of those cases where there has been a jury trial, but it just hasn't been disposed of, it'll show up in next year's data. So it's not like that data is lost. It's just going to roll over to the very next year. And like I mentioned to you last year when I was giving you the Judicial Branch's response to COVID update, jury trials play a very small role in the overall resolution of criminal cases. Usually it's less than 2% of all criminal cases resolve by jury trial. And in FY21, that trend held true. And so if you turn your attention to Attachment 2, it's all the other disposition of criminal cases that occurred in FY21, you'll also see that not only was there 85 jury trials last year, there were 213 bench trials. So approximately 300 total trials statewide in FY21. And so of 300 of 31,000 criminal cases, you're looking at roughly 1% of all criminal cases resolving in trial. And so again, trending very low that it takes a trial to actually resolve a criminal case. And then the balance of them are spread out on the spreadsheet that you have in front of you. But again, that data is only through FY21, which means June 30th of 2021. So I thought you might be interested in a small preview of what you could expect next year when I stand before the committee and give you the second of your two updates that was in HB 2078 last year. And so we asked our stats person at OJA to pull the number of criminal and bench trials that had been conducted in Kansas from July 1 through December 31 of last year. So essentially the last 6 months of the calendar year or the first 6 months of this fiscal year. And the number of criminal jury and bench trials statewide during that time period is 220. And so we're already far out in front of where we were last year. Last year there was 300 again overall, and we've already met 220 in the first 6 months of this year. But the 220, while very positive, is again only a fraction of the total trials that are being conducted in your district courts, because when you, that's just criminal, because when you total up all the other trials like civil, traffic, domestic, juvenile offender, SINC, et cetera, probate, it balloons to 1,245 trials statewide, which is considerable. And so, looking again at attachment 2, the dispositions, which is again just criminal cases, not only will you see the trials reflected, but you'll see other dispositions, the majority of which were resolutions by guilty plea, Madam Chair. And a driver of that, we're told, is that the case is set for trial. It's just the nature of the beast. When you set a case for trial, resolution accelerates. And so, but what it will not show, attachment 2, or what it shows without being explicit in stating, is the work that our district courts are doing with mediation and how mediation is successfully lowering our criminal caseload in Kansas state courts. For example, in Franklin County, which is Ottawa, their chief judge reports that recently they resolved 15 criminal cases without the need for jury trial, and they did that via mediation. Similarly, in Cowley County, where Majority Leader Alley is from, their chief judge reports that 16 felonies had just been resolved by mediation. The majority of those were level 1 through 5 felonies that would have taken a considerable amount of resources for that court and its county, but otherwise those were resolved. And so that necessarily impacts the trial number, but those cases are moving and being resolved. I would be remiss if I said that all of that happened without any of the work beforehand, because recall, like we discussed last year, there is a lot of work that goes into preparing for a jury trial. Clerks and judges, the litigants are subpoenaing and summoning witnesses. They're preparing the courtroom for trial. And a lot of that work, the legwork, must be completed regardless of whether the trial actually goes. Because again, the nature of the beast is the trial inevitably will resolve at the 11th hour on the eve of trial. But we don't want to waste that effort, if you will. And so to avoid wasting that effort, because courtroom time is so valuable, again, recall if we have a smaller number of courtrooms that are COVID compliant, you don't want to lose that valuable time that you could in that courtroom. And so our judges engage in a practice that's called stacking. And so stacking is just simply a practice where there are multiple criminal jury trials set for the exact same date at the same location at the same time, and they're given a priority ranking. And so they'll say, all right, State v. Jurgensen, your case 1. State v. Johnson, your case 2, so on and so forth. And so the attorneys know on State v. Jurgensen, if you're first up, that you're going to go Monday morning at 8 a.m. But if you settle on Sunday evening late, the attorneys on case B, State v. Johnson, know they're up. So that way you're not wasting the courtroom time, and it just goes on from there. There's a small rub to that. You can only set so many cases on a stacking docket like that because of the number of subpoenas and summonses that have to be issued. It becomes cumbersome on the defense bar and the prosecuting attorney's office if you're having to juggle that many cases at a time. So there's a give and take there. But in short, Madam Chair and committee, our caseload is moving. Last February, Senator Thompson and you, Madam Chair, asked us, could we get an idea of the criminal jury trial caseload in the state? And so last February, the Chief Justice sent over a letter that said, here, we surveyed our chief judges. Here are the handful of judicial districts. And so I wanted to revisit some of those numbers for you to give you an update. Last year, we reported in Johnson County, the jury trial caseload was somewhere between 250 and 400. That number has dropped 1 year later to over 200. Celine County, another county that has a high criminal jury trial caseload, last year was 360 to 400. Today, it's 227, a significant drop. In Reno County, it went from 129 to 73. In the mid-sized counties, it's even more stark. Montgomery County, which is Independence and Coffeyville, it went from 60 all the way down to 24. In Hayes, out in Ellis County, 32 to 17. And then I pulled the 9th, Harvey and McPherson counties. In Harvey, they went from 145 to 12. In McPherson, it went from 46 to 5. Even in our small jurisdictions like Pawnee out in Larned or Kinsley, Edwards County, they saw jury trial caseloads drop from 4 to 1 in Kinsley and 10 to 6 in Larned. And so again, the tools you've armed us with have helped us move forward with our jury trial caseload, and things are moving great. So thank you, Madam Chair, for this opportunity.
Thank you again, Mr. Jurgensen, and I'm curious about that State versus Jurgensen case.
I'm diversion eligible.
There you go, there you go. Well, committee, this was an issue that we heard a lot about last session with extending and under what circumstances statutory speedy trial. So I thought it would be informative to hear how that's been working a year later, and we thank you for coming, and we will open it up for any questions from the committee. Yes, Senator Thompson.
Thank you, Madam Chair. Thank you, Sean. Appreciate it very much. Do you think that this backlog, you're going to be able to accelerate the process? It sounds like you're making good progress.
We're making really good progress. I believe that as the status quo exists today, we continue to move forward and move our cases. This will shake out.
So timeline-wise?
We haven't had any chief judge report to us that we need to revisit the timelines.
Okay. All right. Thank you. Thank you, Madam Chair.
Thank you. Committee, other questions? Seeing none then, thank you very much for visiting us from across the street, and we thank you for the update.
Perfect. Thank you so much.
Thank you. With that then, committee, we will open the hearing on Senate Bill 385, but I first want to make an introduction. I have a legislative intern who has started today, Marshall Stula, if you want to come on up and sit back here to help us out with some committee work. He is a third-year law student at KU Law School. So welcome to committee. If you want to sit over there, that'd be great. And we welcome his work on behalf of our committee the rest of this session. So thanks for joining us. Senate Bill 385, requiring registration as a sex offender for certain violations of the crime of breach of privacy. And with that, then, we will ask for a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. As you mentioned, Senate Bill 385 does require registration as a sex offender for some violations of the crime of breach of privacy. You'll recall this bill from the 2020 session, possibly. That was SB 420. Which passed out of this committee, passed out of the Senate 40-0, and then made its way out of the House committee, but did not get above the line on the floor. So it died on the calendar in May of 2020. This bill is the same as Senate Bill 420 as introduced back then, so the refresher on that, there are two amendments. First to KSA 22-4902, and you may recall this from yesterday. This is part of the Offender Registration Act, the definition section. And here the change is to amend the definition of sex offender in subsection B to include any person convicted of breach of privacy as defined in KSA 216101A6 or A7. So only those two subsections, not all convictions of the crime, but only convictions on those two subsections. And I've provided a copy of that statute on the bill brief, so you can see exactly which aspects of that crime are covered, as opposed to which ones are not. And then the second amendment is Section 2, KSA 22-4906. That is the statute that gives the duration of offender registration for all offenders on the registry. The amendment in subsection A there adds these folks to the 15-year requirement. So the person would be required to register as a sex offender for 15 years if they're convicted of one of those two versions of breach of privacy. So that's the legal aspects of it and the reminder of where this has been before. And I know we've got some conferees to talk to you about the policy aspect of it. So I'll see if you have any questions.
Thank you, Mr. Reviser. And for the committee's sake and page 2, lines 13 through 15 is where the first amendment of existing law we can find, and then on page 7, lines 36 through 37. Do I have that right?
Yes, Madam Chair, that's correct.
Okay, so for the committee's reference. Committee, any questions for the reviser? And I believe this is in the same form as it passed unanimously out of the Senate in 2020.
Madam Chair, that's correct as well. This is as introduced. If you followed the bill through the process on the House side, in committee there was an amendment dealing with whether juveniles convicted of these crimes should be required to register or not, but that is not something that the Senate considered. So we went back to the original version that you passed out 40-0.
Right, okay, well, thank you. Committee, seeing no questions then for the reviser, or we do have a question. Senator Gossage.
Thank you, Madam Chair. Could you please tell me again on which page we find the information regarding the 15 years?
Go ahead, Mr. Reviser.
All right, so Madam Chair, the amendment is on page 7 in line 36 and 37. So this is, it ends up being subsection A1 capital M. So subsection A is if you're convicted of one of the following offenses, you register for 15 years. And then it lists A through N, and this would be letter M there near the bottom of page 7. And then, of course, if you're convicted of further crimes, of course, right, multiple offenses, including this one, then there's different durations of registration provided later in the Act. But the one you're concerned about here is just there on page 7, near the bottom.
Thank you, Madam Chair. And thank you, Mr. Reviser.
Thank you. Committee, other questions? Seeing none then. Committee, this is a bill that, like we heard, didn't get an opportunity to be debated in the House in 2020 when the legislature adjourned in March of 2020 due to the pandemic, and the legislature adjourned in March rather than May of 2020. So the proponents of the bill reached out and they said this was a good bill and it had a lot of support. Would you please reintroduce it and work on it? So with their hard work, we have that and we have the hearing today. So want to introduce then our first proponent in-person conferee, Emily Lang. So please introduce yourself and welcome to committee.
Good morning. Thank you guys for allowing me the opportunity to tell my story. My name is Emily Lang. I am 19 now, but when I was 15, I was shopping at a Forever 21 store located inside of the Oak Park Mall. I was in the dressing room in a state of undress when I noticed a phone propped up on a pair of jeans, angled in a manner that could be used to record me. I quickly snapped a photo of the suspicious phone and redressed. Fast forward to April 2018, Johnson County Special Victims Unit detectives found the man who did this to me. He was from Joplin, Missouri, a town some 130 miles south of the Kansas City area. He, like many others, travels to commit these kinds of crimes. His mobile phone contained over 150 images of women in dressing rooms in varying states of undress, apparently unaware that they were being photographed. By its statutory language, this was not by definition sexually motivated until proven. He hired an expert witness to testify that there was a low to moderate chance of recidivism. In this case, he pleaded guilty to the offense in my case and stipulated that it was sexually motivated in exchange for dropping another case against him. Unfortunately, he reoffended the very next day against another 15-year-old girl in Johnson County. As a teenage girl, my world has forever been changed by this experience. I am now cautious while shopping and especially when trying on clothing. I am more cautious now because I realize the threat of being unaware. He has negatively impacted my life forever, and in the era of social media, will these pictures ever show up again? I don't know. It seems like common sense that taking photos of a 15-year-old girl in a state of undress is a sexually motivated crime. Unfortunately, laws regarding privacy have failed to keep pace with the fact that mobile cameras on phones are in nearly everyone's possession. Wiretapping and photographing a person in the state of undress without their consent are not the same thing and should not be treated as such. As cameras get smaller, this will be easier and easier. Voting yes on Senate Bill 385 will save the next victims from having to sit through a preliminary hearing, listening to the person who violated them hire an expert witness to testify on their behalf that there is a moderate to low chance of recidivism, only for him to to reoffend the very next day. The registry is so very important to me as a member of the community, but even more as a teenage girl. When I entered my freshman year at KU, I soon learned that one of my new friends was also a victim of this kind of crime. Her situation involved a man upskirting her and her Catholic school uniform at a local Quick Trip. Once I pledged a sorority and moved into the chapter facility, my across-the-hall roommate learned that her trusted male high school choir teacher had allegedly filmed her and her classmates while changing in his office. This kind of thing, unfortunately, is not rare, and it is my hope that as parents, aunts, uncles, and grandparents, for you to think about your loved ones and how you would want their case to be handled. I want to be able to trust that the people who commit these kinds of crimes are registered to keep our community safe. Thank you, guys.
Thank you, and committee will have all questions at the end of all the testimony. Thank you very much. Next, then, we will hear from Annabelle Davis. Please introduce yourself and welcome to committee.
Hi, I'm Annabelle Davis, and I'm a 17-year-old girl who is a victim of breach of privacy. When this happened to me, I hadn't even been 15 for an entire month. It sounds weird even saying that almost 3 years have passed since that day. On May 31st, 2019, I was at a Target trying on swimsuits with one of my friends. We went into the dressing rooms and each went into a different room. I had heard a man's voice and heard him ask the Target worker if the dressing rooms were for everyone, and she said yes, which I thought was weird but didn't think much more of it. I began to try on a swimsuit top by taking off my shirt and my bra but leaving my shorts on. As soon as I put the top on, I noticed a phone camera on the top of the dressing room door. At this moment, I noticed that I didn't have my top on all the way, so there was definitely some nudity. I immediately went to the door and opened to yell at whoever was on the other side. It was such a traumatic experience, I can't even remember what I said, but I do know that I said that he needed to get out. When I opened the door, I was able to get a good enough look to look at him and remember what he was wearing. When I yelled, he put the phone in his pants, in his arms, and ran away instantly. I yelled for my friend on the other room, and I told her I needed help. The Target lady came back with no help whatsoever. As a young girl, it was a disappointment when she seemed to not believe me. As an individual, my life has not been the same since that day. There isn't a single day where I don't think about what happened to me. I mean, it's life-changing. It's definitely opened up my eyes as a young lady, and it has made me pay really close attention to my surroundings. Unfortunately, I just threw away the t-shirt and Nike shorts that I was wearing that evening because I never want to wear them again. For several days and weeks after this happened, I couldn't even look at my body. I hated it. I was afraid to shower, so I did with clothes on. I was afraid to be alone or with people that I didn't know or fully trust. There are still triggers that I deal with to this day, and I just try to avoid them as much as possible. I really try to avoid trying on clothes in any store because I am so nervous of it happening again. I was in a different Target just a few days ago and needed to try something on for an upcoming event, but couldn't bring myself to do it and decided to take my chances of what was going to happen. I have not tried on a swimming suit in any dressing room or store since that day. It's been such a crazy situation that no one really thinks about, but now it has happened to me, and I realize no person should ever go through this. When you first hear about the situation, it doesn't sound as bad because there are no contact involved, but it's still a traumatizing event. I feel like a piece of me has been taken away, and no girl should ever feel like that. I believe that it is very important to make changes to the laws and punishments for the certain breach of privacy cases in Kansas. The current laws are outdated and are not current with the technology and accessibility individuals have to cameras and video recording. Unfortunately, individuals who commit certain invasion of privacy crimes tend to commit those more than once. In my situation, the perpetrator had been given probation for doing the same thing to another teenage girl and turned around and did it to me just 24 hours after receiving his sentence. If these types of crimes are not treated as seriously as they are, hopefully criminals will be less likely to commit them. Thank you.
Thank you. And next we will hear from Beth Hyriggs. Please introduce yourself and welcome to committee.
Hi there. My name is Beth Hyriggs. Thank you very much for allowing me to present and allowing these women as well. I was in front of you 2 years ago, almost to the day, to advocate for this bill. Unfortunately, COVID pushed it back. So I am proof that it does not just happen to teenagers, it also happens to older women as well. I'm a mom of 3. The main reason I am here today is due to my experience in dealing with a perpetrator and invasion of privacy. My instance, as described in the document in front of you, involved a friend who is a victim of a man trying to take a video of her while she was trying, again, on swimsuits in the Nordstrom Rack in Lenexa, Kansas. I am not the victim, but I am the witness to it. She came to me in the dressing room and told me what had happened, what she believed was happening, and said, nobody's going to believe me. And so that's when I had the idea to trade places with her. I went into her dressing room, adjacent to Mr. Phelan, turned on my camera, bent down, and saw his hand taking, with the cell phone out, as you will see, taking a video of me, of her. And I said, I see you. That led to his arrest. Mr. Phelan denied his wrongdoing for over 2 years, even with the evidence presented in that image. The biggest thing that I am here and the biggest heartbreak for this bill is that they settled with my friend and the state last year, a few days before his scheduled trial, with a guilty plea agreement. And because this was not set into law, his guilty plea and his settlement did not come with a sex offender registration. He has 180 days probation. He had a sex offender evaluation, but no registration. I made a promise to him in my impact statement that I would be here today, and I would be continuing to fight to protect other women, other men from things like this to happen again. The law states that we must prove that the act was sexual in nature for an individual to register as a sex offender. The image in front of you shows that there is no other reason to have your camera out to somebody that is in the state of undress unknowingly than for it to be sexual in nature. This action is very clear in its intent. We are advocating for your support and your senator's support to change the law for the punishment to fit the crime and to help protect individuals from having to experience this traumatizing event and lack of respect after a guilty plea. These acts should be punishable in the correct manner and aid in preventing these actions from reoccurring to other women and men in the future. Thank you very much for your time.
Thank you. Thank you all for appearing today at the Capitol. I'll ask, are there any other proponent conferees in the committee meeting room or online who want to offer proponent testimony? I don't see any. Do we have any neutral conferees in the committee meeting room or online? Not seeing any then. Any opponent conferee testimony in the committee room or online? Don't see any. Committee, are there any questions for the proponent conferees? Seeing none, then thank you all very much for advocating for this and taking your time to present this to the legislature, to this committee, and we appreciate you doing that. So thank you very much. With that then, committee, we will close the hearing on Senate Bill 385 and open the hearing on Senate Bill 408, increasing the criminal penalties for multiple thefts of mail, and ask for a bill brief from the reviser.
Thank you again, Madam Chair. Senate Bill 408 does increase the criminal penalties for multiple thefts of mail. For those of you that might have been following House action last session, this was HB 2229 that did get out of the Committee on Judiciary, but did not get above the line and ended up being stricken from the calendar at the end of the 21 session. So it did not carry over. This is a reintroduction, essentially, of that House bill as a Senate bill, requested here in committee by the chairperson, I believe, and the committee's name appears at the top there. The bill amends the theft statute, which is KSA 21-5801, and the amendment provides that theft of property that is mail of a value of less than $1,500 from 3 separate locations within a period of 72 hours as part of the same act or transaction, or in 2 or more acts or transactions connected together or constituting parts of a common scheme or course of conduct, that becomes a severity level 9 person felony. And I note in the bill brief that the current penalty for that same crime would be a Class A non-person misdemeanor. That's what happens when you're convicted of theft of property or services of the value of less than $1,500. So this would create a special category of those kinds of thefts of that value that raises it from a Class A misdemeanor to a severity level 9 person felony. And then I note that the bill defines mail there on page 2 in line 17 as a letter, postal card, package, etc., as you might expect, sent through the United States Postal Service or other delivery service, or any article or thing contained therein, or a sealed article or thing addressed to a person. So mail is USPS mail, other delivery service mail, and then other things that are addressed to a person and maybe left on a porch or placed in a mailbox, that sort of thing. So I wanted to highlight the definition there on page 2 to give you an idea of what we're talking about covering. I think that's all I have, so I'll stand for questions.
Thank you, Mr. Thompson. Are there any questions from the revisor's office? Seeing none, thank you. We now turn to our first proponent, Ed Klump, Legislative Liaison of the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and the Kansas Peace Officers Association. Welcome back, Ed.
Thank you. Thank you, committee. I am Ed Klump here representing the 3 associations. Senator Wilburn listed for me there. Thank you. We stand in support of this bill. We testified in support of it before when it was brought up. This is an ongoing problem, these theft of mail. And I point out in the bill, the definition of mail here covers more than just U.S. mail. It is all packages delivered. I think that's important for you to know because this bill protects Kansas merchants who suffer losses when those packages are stolen off front porches. The bill does something that is not unprecedented. If you look on page 1 of the bill, lines 32 to 36, you will see a provision in the existing law that was put into place many years ago, I forget when exactly, that dealt with a similar problem with shoplifting. And the problem we had back then was we had people who would actually gather shopping lists from people who would buy the stolen property. They would then go to a series of stores, merchants, and steal the items that people had ordered from them, and then they would go and sell them to those individuals at a reduced price because they didn't pay anything for them. And so we asked for this revision in the law to address this serial shoplifting, we called it, and it worked. We saw a reduction in those types of cases, and it relieved the merchants of significant losses. Not that we don't still see that today, but not nearly like we were back then. So this is a tried and true approach. We believe it'll work on these package thefts. I will tell you our experience is with more Ring devices and video doorbells and video surveillance on houses, we get some pretty good pictures anymore of these thieves, although it's reported to us usually later when the people come home and discover the package not there. But we get pretty good video. Sometimes we can identify those people. Sometimes we identify vehicles. And on occasion, we have the good fortune of going to those people, and when we confront them, we find other packages that those people have stolen off of other porches. And in today's world, FedEx and UPS and Amazon and everybody else that does these deliveries keep a pretty good record of where those deliveries were made, the time they were delivered, where that package was left, and it's easy to track back, gather the evidence, and make these cases. As you know, the pandemic really greatly increased home delivery of many, many items. And so now we have people going back to work. These items are being left on front porches when they're delivered, and sometimes will sit there for hours before those people come back home to retrieve it off their front porch. There's been a lot of work done by the delivery systems to create alternatives for people to use to have those packages delivered, but we still have this problem, and it's a huge problem. We think this is a good solution for the problem. We think it's a workable solution. Based on our experience with the shoplifting provision, we believe it'll work, and we would encourage you to pass the bill favorably. And I'll stand for questions when it's appropriate.
Thank you, Mr. Klump. As keeping in tradition, we'll hear from all the proponents, and then we'll open it up for questions. The next conferee I have on the list is Greg Smith, Special Deputy Sheriff for Government, Veteran Crime Victims Affairs, Johnson County Sheriff's Office. Welcome to the committee.
Thank you, Mr. Vice Chairman. I am Greg Smith. I'm the Special Deputy for Government Affairs for the Johnson County Sheriff's Office. I'm sure many of you have seen the videos that you can find on YouTube and other websites of folks that have had things stolen off of their front porch, and then you've seen what now appears to be the only defense against that is where people set up these packages that explode and send paint or glitter or something like that. They're humorous. I see you all laughing. Not that we recommend you doing that, but it's funny to watch. But what isn't funny, as the previous conferee said, is the amount of economic loss that comes from this. Folks get these packages on their front porch, they come home and they're not there. And yes, Ring doorbells and Blink and all these other security systems are helpful in identifying these people, but it doesn't prevent the theft itself. Package theft now in the United States has become one of the largest crimes that there is. Research that we did shows that between March and July of 2020, 1 in 5 Americans reported having a package stolen off of their porch. The average amount of loss was $106. So you add that up over these serial folks, which a lot of these people are, that's how they're trying to make their living. That's a lot of money that can be grabbed rather quickly and rather easily. So this bill, again, as the previous conferee said, provides that serial shoplifting prosecution, which we hope would be a deterrent to some of these folks trying to do this type of stuff, and we're very supportive of this. Punishment fits the crime with this bill. I'm happy to stand for questions.
Thank you, Mr. Smith. I think we have one more conferee, then I'll open it for questions. Is Eric Stafford, Vice President of Government Affairs of the Kansas Chamber. Welcome to the committee, Eric.
Thank you, Mr. Chairman and committee members. Eric Stafford with the Kansas Chamber, Vice President of Government Affairs. Underneath the banner of the Kansas Chamber is the Kansas Retail Council. We serve as a state's affiliate for the National Retail Federation, so we have a good contingency of retail members within the chamber, and this issue was brought to us by them. Some of our members have been engaged with law enforcement to work on the language, trying to have these penalties mirror shoplifting. Senate Bill 408 is identical to House Bill 2229 that has cleared committee and was below the line, but sat below the line because last year in committee there was an amendment added that had objection from some in leadership, is my understanding. So it never went anywhere. But overall, good support from the committee on this bill last year. Yeah, this is a bill that was brought from our membership, as I said, to provide clarity both for retailers and for law enforcement on how do we handle theft of multiple packages as online shopping has become a bigger issue. There's a link in the PDF document of our testimony that you have to survey of 2,000 customers and their online shopping experience. On average, from the 2,000 that responded, they said that they spend $220 a month shopping online, and that 56% have had at least one package stolen, 22% twice, 10% three. So you're starting to see, we've all seen the Ring videos of individuals going up, the porch pirates going up and stealing these boxes, especially around holiday season. And this isn't, going, stronger, making this a tougher penalty. Again, it's just trying to make it consistent with shoplifting. So I'd be happy to answer any questions at the appropriate time. Thank you very much.
Thank you, Mr. Stafford. Are there any other proponents here today that would like to speak to this issue? Seeing none, committee, we'll open it up for questions. Yes, Senator Gossage.
Any of the proponents can come up to answer the question, if you don't mind.
What's the question? Maybe then they can determine.
Then maybe they'll know. There you
Yes.
go. Okay. My question is just that it appears that we have made it more stringent or a stronger punishment if it's $1,500 or less. Is that what we're doing with this bill?
Good.
I think
Please
I can take that one.
Please
Ed Klump.
introduce yourself so we can, thank you.
Ed Klump with the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers. And what it's doing is when you have these people who are the prolific thieves who are going from door to door over a short period of time and committing these thefts, each theft is an independent crime. And so since we've raised the penalty or the level where it turns to a felony to $1,500 in Kansas, and by the way, if you've been watching California, they're in an uproar now because theirs was raised to $900. But now all these crimes are misdemeanors. So now they never reach a felony level if they go out and steal 20 packages. It's 20 misdemeanors. It's not any more than that. And so what this does is it separates those that might steal one package from those that are making a living off of doing this, and we roll those together then to put that value together to make it a felony crime.
That's what I needed to know. Thank you. That makes perfect sense. Thank you, Madam Chair.
Thank you.
Thank you, committee. Other questions? Seeing none then, do we have any neutral conferees or opponent conferees in the committee meeting room or online? Seeing and hearing none, then we will close the hearing on Senate Bill 408. And thank you all for coming and providing testimony. Committee, we next have on our agenda final action on House Bill 2361. You'll recall that authorizes the Supreme Court to adopt rules establishing specialty courts, creating the Specialty Court Funding Advisory Committee, and the Specialty Court Resources Fund. If we could have a little short bill brief from the reviser to remind the committee of the bill. We do also have a technical amendment for the bill because this is a carryover bill from last session 2021. So we have to update the citations to the correct date of the statute that we're amending. Thank you, Mr. Thompson.
And thank you, Madam Chair, and thanks for helping get me started on the amendment there. You'll notice that it is a proposed substitute. This has two sections in it, the amendatory sections, and the legislature amended both of those sections last session. So in order to properly enact a bill, you have to show the current law with the amendments on it. So if you choose to work the bill, this is how we would recommend you send it out as a substitute with the correct versions of the statute in it, and the exact same amendments just put on the correct updated 2021 statutes. So the reminder of the prior bill, it has a couple of pieces. The first is a new section that just directs the Supreme Court to adopt rules about specialty court programs. They actually already have a couple of them, but this would give them a little more to do in those rules. It also, Section 1, creates the Specialty Court Funding Advisory Committee within the Judicial Branch, and it has some members there listed on the first page. including some legislative members, of course, and some members appointed by the Chief Justice. And then there is also the final thing in Section 1 is a Specialty Court Resources Fund that is created in the State Treasury that will allow acceptance of grants and other appropriations into that fund, and then they would be expended for the purposes laid out there in the section for specialty court programs. The second section of the bill is the amendment to KSA 21-6604. That's the really long list of dispositions that can be given to you or pieces of your sentence that can be given to you when you're found guilty of a crime. So that's why it's so long. There's a number of things that the court can do. And if you have the bill, which I don't know that you do, I guess you have the proposed substitute. I can tell you that the change in that long statute in the substitute is on the bottom of page 6. And the original bill was on page 5, but on the substitute proposal you have, it's on page 6. And if you'll give me 1 second, I realize I need to send that to the committee staff so that that can be shared with everyone who wants it. There we go. I had it ready, I just forgot to do it. So if you're looking at that, it just simply says the court can order the defendant to participate in a specialty court program under Section 1. So that just essentially ties in the criminal sentencing provisions with the provisions of Section 1 and says this is an option that all courts may consider. And then the amendment, final section in the bill is Section 3. That's an amendment to the expungement statute, which I think you are all very familiar with, KSA 21-6614. The change there is fairly early in the statute in subsection A, where we're talking about expungement as an option. And in your bill copy, that would be on page 20, near the top of page 20. So currently you would have to wait some number of years, and for certain crimes you will still have to wait some number of years. But if you've completed the requirements of your specialty court program, you may petition the district court for expungement, and the court can waive all or part of your docket fee. So that's a special provision that would allow for expungement in a slightly different way for those who complete these specialty court programs. Remember, these are mostly going to be lower level offenders that are offered this opportunity. They would have to wait, 2 years, 3 years, 5 years, depending on the crime. And so this would allow them to get out of that a little sooner if they complete their program and possibly even have their fees waived. So those are the big pieces of it. I'd be happy to answer questions.
Thank you, Mr. Revisor. A quick question, given the Judicial Branch update that we received today, and one of the handouts that was circulated by Mr. Jurgensen was a page on specialty courts, breaking the cycle. I know it's not your handout, Mr. Thompson, but is that the kind of specialty courts that we're talking about? And I know you're not a conferee on the bill either, but just for the education of the committee and those following along in the committee meeting room and online, does this bill kind of impact the specialty courts that we heard a brief presentation about today?
Thank you, Madam Chair. And yes, as I mentioned very briefly way back at the beginning, and I probably buried it in the deluge of technical amendments and other things after that, the Judiciary already is using specialty courts. There are a number of them in use across the state. The Supreme Court has rules 109A and 109B dealing with specialty courts. Some of the language in this bill and in other bills you've seen on this issue in the past draw from those rules to try to be consistent. And then the definition at the end of Section 1 defines specialty court the same way, essentially, that the Supreme Court defines it. It's a program, a district court program that uses therapeutic or problem-solving procedures to address underlying factors contributing to their involvement in the judicial system. And that includes, but is not limited to, mental illness, drug, alcohol addictions, the kind of things you're seeing on this page. Veterans courts, drug courts, mental health courts, et cetera.
Thank you. With that committee then, are there any questions on the technical amendment that is a proposed Senate substitute for House Bill 2361? Seeing none then, I move the amendment. Do we have a second? Senator Haley, I heard first. So thank you, Senator. With that, committee, any discussion on the motion? Seeing none, all those in favor, aye. All those opposed, no. The motion carries. With that, then, we are back on the bill. Do we have any other amendments? Seeing none, then, do we have a motion on the bill as amended? Senator Gossage.
Madam Chair, I move that we pass this bill out as amended.
Pass it out favorably as amended?
Favorably as
Yes,
amended.
thank you. A second. Do we have a second? Yeah, Senator Corson, thank you. Committee, any discussion on the motion? Seeing none, then, all those in favor, aye.
Aye.
All those opposed, no. The motion carries. Thank you, committee. We will probably be working further bills that we have heard. We'll probably be working those either tomorrow or Thursday, so please be prepared with any amendments that you may have. And we have Senator Baumgartner, looks like, has a question.
Yes, Madam Chair. Knowing the history of Senate Bill 385 prior, is there a reason that we don't want to move on that today?
Thank you, Senator. The Senate committee that heard this bill in 2020 was different than the Senate committee that we have today. For instance, I and a couple of us were not on this committee in 2020, so just want to give those folks an opportunity. If there's any amendments to bring, please get those ready. I would anticipate working that tomorrow.
Okay.
So thank you for the suggestion. Appreciate that. Committee, any other questions? Seeing none, then we are adjourned.